because the money that's going into the pocket of Turning Point USA executives and vendors, if they've been disciplined and they are sitting on indictment for state or federal charges, they should not be receiving funds unless fully disclosed. That is a fiduciary duty to disclose. And if donors sue for breach of fiduciary duty under Arizona law, there is no cap on damages. Did TPUSA's board of directors violate fiduciary duties for Turning Point USA? We're going to find out in this video. Like, subscribe, hit that notification bell, and let's get right into it. So on April 26 in 2024, an Arizona grand jury indicted Jake Hoffman and Tyler Bowyer with 9 felony counts each, with conspiracy, fraudulent schemes, forgery. It's not my opinion, it's fact. On November 14th of 2025, President Trump actually issued federal pardons for these gentlemen, and I'm using that term lightly. Article 2, Section 2 of the Constitution grants pardon power only for federal offenses. A spokesperson for Arizona Attorney General Chris Mays stated that the pardon will have no impact on the state's case. And as of January 26, Jake Hoffman and Tyler Bowyer remain active criminal defendants in Arizona State Court. And according to tax filings and analysis documents, after April 2024's indictment, payments totaling $475,000 and change went to companies owned by Jake Hoffman. Under Arizona nonprofit law, when boards continue paying vendors or employees who are under federal indictment, they must prove that those payments are serving the nonprofit's mission better than protecting its reputation would have. That's not my opinion. That's fiduciary duty law. Now, in Arizona Revised Statutes, Title 10, Section 10, 11.830 governs nonprofit corporate directors. It requires directors to act in good faith and in a manner that the director reasonably believes to be in the best interest of the corporation, of the mission. Not the best interest of the executives, not the best interest of vendors, the corporation, the mission. This creates 3 mandatory duties. Duty of loyalty, which you put the nonprofit's interest ahead of any personal interest or relationship or business relationship every single time. Duty of care, you make informed decisions. You gather information, you consult experts, and you document your reasoning. And then you have a duty of obedience. You have to ensure that the nonprofit operates according to its stated mission every single way, every time, which complies directly with the law. If you violate these duties, you face personal liability, not the nonprofit. You personally face liability. Internal Revenue Section Tax Code, Internal Revenue Code Section 4958 addresses excess benefit transactions. And an excess benefit transaction occurs when a nonprofit pays a disqualified person more than fair market value for services. The penalty structure: if you receive an excess benefit, you personally owe 25% excise tax on the excess amount. And if you don't correct it by returning the excess to the nonprofit, that penalty increases 200%. So adding 200 to the 25%, 225% in total, which if you're a board member and you approved an excess benefit transaction and the IRS determines that you knew or should have known it was improper, you also face 10% penalty up to $20,000 per transaction. So say if there's 5 questionable payments, that could be $100,000 in personal penalties from your personal bank account. April 26 of 2024, Arizona grand jury returns indictments in state of Arizona versus Bowyer, Hoffman, and others. Jake Hoffman, defendant 4 in this case, has 9 felony accounts, and Tyler Bowyer is defendant number 2 in this case, also with 9 felony accounts. The charges were public. News coverage has been extensive. Anyone searching either name would find these indictments. At that moment, Turning Point USA's board had to make a decision. For Jake Hoffman's companies, stop the vendor relationships, distance from an indicted state senator whose company was banned from Facebook for running a troll farm, and also indicted on federal and state charges for doing fraudulent schemes. For Tyler Bowyer, place the COO on an unpaid leave pending trial. I'm pretty sure this is why Charlie Kirk had mentioned that Tyler Bowyer is going to be replaced as a COO with Justin Strife. According to analysis documents reviewing tax filings, after the indictment, payments to companies owned by Jake Hoffman totaled $475,000. So, according to Form 990, Part 7 for fiscal year 2024, Tyler Bowyer's disclosed compensation was $337,575, and this was disclosed in fiscal year of 24. So, before that, in 23, it showed $79,000 in change. Here's the fiduciary duty test. Did paying an indicted vendor after his indictment serve the mission of educating college students about conservative principles? Did it serve the mission better than terminating the vendor relationship would have? Did employing a COO facing 9 felonies and increasing his compensation from nearly $80,000 to over $330,000 in the year of his indictment serve donors' interests? This board must be able to answer those questions, and their answers must be documented in board meeting minutes, supported by independent legal counsel and disclosed to donors. Because if they can't prove that the decisions serve the nonprofit's mission instead of the personal financial needs of the indicted individuals, that is a fiduciary duty violation. I'm not saying that these payments are violations. I am saying that Arizona law requires the board to be able to prove that they aren't. And that requires documentation. Arizona nonprofit law requires a good faith disclosure of material facts to donors. Is your COO facing 9 felony counts of a material fact? Yes. Is your vendor being indicted for election fraud? Is it a material fact? Yes. I reviewed publicly available TPUSA fundraising material for 2024, and I found no disclosure of these indictments. I reviewed their website donor pages. There's no disclosure. I reviewed publicly available communications and no disclosure. In fact, seems like they're hiding the information that they're still under state indictment celebrating some type of presidential pardon from Trump when it has no overseeing in the state of Arizona. You might as well try to pardon somebody in Germany because it's not going to work. If you donated to Turning Point USA between April 2024 and today, did anyone from the organization inform you that the COO was still facing 9 felony counts? A major vendor under indictment for 9 felony counts. Hundreds of thousands of dollars being paid to an indicted defendant's company. You must have learned this from news reports if you even knew it at all. From investigations like this one, the one that I've been doing over these episodes, this is probably where you're finding this information because guess what? I guarantee you, it's my opinion, I could be wrong, they're hiding this information from you. Because the money that's going into the pocket of Turning Point USA executives and vendors, if they've been disciplined and they are sitting on indictment for state or federal charges, they should not be receiving funds unless it's fully disclosed and it is certainly a fact that it is serving the mission better than not paying them. Does that make sense? That is a fiduciary duty to disclose. When material facts affect donor decisions, boards have a legal obligation to provide them. February of 2024, New York jury finds Wayne LaPierre, former NRA CEO, personally liable for $5.4 million for failing to properly administer charitable funds. CFO Wilson, $2 million in personal penalties. What did they do? Routed nonprofit money through vendors to provide personal benefits. The court didn't find the NRA and just call it a day. They went after the individuals who made these decisions. Personal bank accounts, personal assets. Wayne LaPierre is now banned from nonprofit leadership for over a decade. Every TPUSA board member who voted to continue paying Hoffman's companies and employing Bowyer after 2024 should understand you face the same legal implications that Wayne LaPierre faced. He did time. He paid millions. If the IRS determines that the $475,000 sent to Hoffman, paid to Hoffman, was excessive, he faces from 25 to 225% in personal excise tax. If Bowyer's compensation increases in his indictment year and is deemed excessive, he faces the same. And it all matters in the fact of the mission of the organization, and if it's more important to have this person paid or serve the mission. And if it was important to pay, then what was the reason, and was all of this agreed upon and explained to donors? Every board member who has approved these payments, if this was not done specifically, it's up to $20,000 per transaction per board member who approved this. And if donors sue for breach of fiduciary duty under Arizona law, there is no cap on damages. So if you're a donor and you weren't notified of these duties being broken, and indeed they might have been, then you have a right to file a lawsuit and claim for personal unlimited liability. So here are some questions that the board needs to answer. Did you convene a board meeting in April of 24 to discuss the indictments? Did you consult independent legal counsel about your fiduciary duties? Did you vote on whether to continue the Hoffman vendor relationship? Did you vote on Bowyer's continued employment and compensation? Did Bowyer recuse himself from voting on his own compensation? What about voting on how we're going to pay Hoffman? Did you vote on that as well? And did Bowyer recuse himself from these votes? Because we could request the minutes, but are they going to give it to us? They don't have to, I don't think. What business reason justified paying a criminally indicted state senator, a vendor of TPUSA, $475,161 after his indictment while his trial is still pending? How did that serve TPUSA's donors' mission better than terminating the relationship altogether? What reputational damage assessment did they conduct? Why weren't donors informed? And if they were, how come nobody's talked about it? Do you believe the executive indictments are material facts donors should know? And about the documentation, where are the board minutes from April 2024 to the today? Can you produce the business justification in writing that this is serving the mission to pay these vendors, to have Tyler Bowyer in a high capacity all the way from 2024 while he's under state indictment? Even if he was federally pardoned, he was under indictment federally and state all the way up until 2025, near the end of the year. So every single payment, every salary payment, every vendor payment, this could be an excise tax and a lawsuit that nobody saw coming. Nobody's talked about it. Have they gathered comparability data showing that these payments were fair market value? I'm going to cite Arizona nonprofit law, and I'm going to ask whether documented procedures were followed. And the law says, put the mission first, disclose material facts, document decisions. The evidence available to me shows that payments continued after indictments. No public disclosure found. Meeting minutes are not publicly available, even though the public subsidizes them as a tax-exempt organization. If you donated to TPUSA in 2024, 2025, even 2026, IRS Form 13909, tax-exempt organization complaint form, Arizona AG's office, donor protection complaints. I'll put the link down below. You can also hit up TPUSA directly and demand disclosure in board meeting minutes. You have a right if you're a donor. The board has mandatory duties under Arizona law. If they fail to meet these duties, they face personal liability. That is not my opinion. That is the law. They call me Danks on lock. Yeah. They call me Danks on lock.